Okay, good morning, everyone, and welcome to Are You Aware of the Changing Legal Landscapes in the New World of Work? Please note that today's webinar is being recorded. We will be taking questions at the end of the presentation and ask that you submit your questions through the chat. My name is Tina Stevens, and I'm a project manager with the Workforce Planning Board of York Region. WP Board is one of 26 local boards across the province of Ontario that gathers local labor market intelligence on the demand side of the labor market by working with employers to identify their current and emerging skills. Over the past 24 months, the COVID pandemic has affected us all and has had extraordinary impact on our local economy. For individual businesses, the fallout was experienced in diverse and varying degrees. COVID-19 has changed the way we work, perhaps forever. It doesn't matter what sector you operate in, employees' expectations have changed, workplace standards and protocols have evolved. With us today to talk about some of the changes in protocols are Joel Smith and Seth Holland from Williams HR Law, located in Markham. Joel is a partner with Williams HR Law, where he practices management side labor, employment, and human rights law. He provides legal and strategic advice to training to both unionized and non-unionized employers in all areas of labor and employment law. Joel represents employers before various courts, boards, and tribunals. Joel regularly presents before employers and human rights resource professionals. Joel has presented to the Human Resources Professionals Association, including the HRPA's annual conference, annual HR summit, annual HR law conference, as well as the Toronto Entrepreneurs Conference, the CPA Ontario Association, and various chambers of commerce across Ontario and other industry associations. Joel's writing is frequently published in labor and employment law and human resource publications, including Canadian Employment Law Today, HR Reporter, and HR Professional Magazine. Welcome, Joel. Seth is a lawyer at Williams HR Law, where he practices in all areas of labor, employment, and human rights law. Seth provides legal advice and representation to both unionized and non-unionized employers operating in Canada in all areas of labor and employment law. Seth also regularly conducts workplace investigations into complaints of workplace harassment and misconduct. Seth has presented at several educational speaking engagements for employers and HR professionals on major developments in Canadian employment law. Seth has also written for a number of employment law and human resource publications, including Canadian Employment Law Today and HR Professionals Now. Welcome both Joel and Seth. Let's get started by turning the reins over to our guests.
Thank you so much, Tina. And thank you to Al and everyone at the Workforce Planning Board of York Region for hosting us here this morning. And of course, thank you to those of you who are attending this morning. This is a presentation, or a variation, I'll say, of a presentation that we really give year after year, where we provide updates about the big developments of the past year and trends in HR law for the year ahead. And this year in particular, there is just so much going on in HR law that employers need to be aware of. First of all, there's the typical legislative updates, case law updates that impact employers year after year as the law continues to develop. But on top of that, over these last year or two, really, we've been seeing the ongoing impact of social justice movements, really, and how those are impacting workplaces in a variety of ways, as well as, of course, there's so many different ways that the pandemic has impacted workplaces, as Tina just mentioned. And so there's a lot to talk about here, but we've really tried to narrow down to the most important developments and trends for York Region employers to be aware of from last year and coming into this year as we look forward to the year ahead. And so Tina just introduced us. I won't spend any more time there. And I'll just shift right over to our session roadmap. So today, the intention really is to walk you through high level, a heat map of some of the really key developments. And these developments are taken from what we know is critical for employers to know from our hands-on advice, our hands-on representation of clients in court, in tribunals, in grievance arbitrations, and more, and our assessment of the developments that just are arising from case law and legislation that's continuing to impact the workplace. And so today we're going to focus on 4 key topics. And I'm going to ask Seth to do some of the heavy lifting here this morning. Seth's going to bring you through first Bill 27. And so that's the Ontario bill that was just tabled late last year, that's creating a new requirement to have right to disconnect policies for many Ontario employers, as well as created a ban on most non-competition clauses in employment agreements in Ontario. He'll then bring you through some new really key developments in employment agreement enforceability in Ontario, as well as key developments in the law surrounding workplace harassment and workplace investigations. That's just so important for employers to know as the trends around harassment investigations continue to push really quickly year after year. And then at the end, I'm going to close out with what's been the biggest development and really the biggest trend from last year and going into this year for most employers, and that's vaccination policies and the many different legal implications of those types of policies. Then at the end of our hour here this morning, we intend to leave some time to take questions, take your Q&A. What we'd ask is if you can please put your questions in the Q&A box as opposed to the chat box in Zoom. That'll ensure that we're able to see those and can get to as many questions as we can in the limited time we have here this morning. Now, I will say from the outset, I can't help myself as a lawyer. The information we're going to provide here this morning is just that. It's legal information, and it shouldn't be considered specific legal advice because, of course, we don't have the full context and the full circumstances that apply in each individual employer's circumstances. But with that said, I anticipate you'll be able to get really useful information here this morning that you can take back to your workplaces and implement to try to make sure that you're protecting the companies from liability and taking the right steps moving forward to improve that employer brand and move forward through this pandemic. So before I pass it over to Seth, I just want to give you a high-level snapshot of some of the things that we're seeing that are impacting employers right now before we get into the specific developments that I mentioned a moment ago. And so the first here is that COVID-19 is fortunately on the decline at the moment. The spike that we saw of COVID-19 cases with the Omicron variant in December and January is starting to decline. And so we're seeing fewer cases in the province and the country. Of course, we all know that we don't know exactly how many cases there are because the government has stopped testing the same way that they were. But from hospitalizations and what have you, we're able to see that we are in the decline. That's, of course, led to the big news over the last couple of weeks, where many of the COVID-19 related restrictions in Ontario are being lifted. Of course, the big development being that as of March 1st, there will be no longer be the vaccination passport requirements for settings across the province as there has been these past few months. Now, keep in mind that businesses are entitled to continue to require proof of vaccination at their option, but the requirement to do so will be no longer as of next week. Beyond that, I just want to discuss really, really high level. There's a developing body of case law related to COVID-19 in Ontario, especially in the union context. But as we go on through the year, we're anticipating to see more and more in the non-union context as well. And a lot of that law relates to vaccination policies. I'll be speaking about some of the law we've seen there when I speak about vaccination policies shortly. And we expect to see a lot more of that law over the coming months. But there's other decisions related to COVID-19 that we're anticipating and we're starting to see as well. For example, we're anticipating a really major decision from the Court of Appeal over the next couple of months, which will confirm whether employers that temporarily laid employees off in response to the pandemic are going to be liable for constructive dismissal of those employees. And in which case, if they are, they'd be liable for those employees' termination entitlements as though they let them go without cause. So that's a really big development that employers should be mindful of, especially those that had laid people off for a long period of time, or perhaps still have employees on layoff at this stage since kind of the early in the pandemic. That's going to be a really big development for those employers to focus on. In relation to that, there's also a big legislative change that we're continuing to see, and we're anticipating further changes in. And that's related to the infectious disease emergency leave regulation in Ontario. That's the regulation that is essentially deemed many employees for the purposes of the Employment Standards Act who have been laid off or who've had their hours or compensation reduced significantly because of the pandemic. It's deemed them to be on a job protected leave under the legislation as opposed to being on a layoff for the purposes of the Employment Standards Act. So that relates to that big decision that we're expecting from the Court of Appeal. It is going to have a big impact on those same employers that I was referring to. So as it stands right now, that regulation has been extended a number of times throughout the pandemic. And as of right now, it's been extended up until the beginning of July of this year. And so employers should be mindful of that, especially if you may still have employees on layoff as a result of the pandemic. Of course, when we're talking about legislative developments, I have to mention again, Bill 27 that Seth's going to be speaking about. And then just this morning, news has broken that the Ontario government is planning to table legislation imminently that would require employers to inform their employees through a specific policy they'd have to implement about whether and how those employers may electronically monitor their employees. So that would be things like keyboard stroke monitoring, GPS monitoring of work cell phones, GPS monitoring of work vehicles, and others, which are quite common in a variety of different workplaces. So that's another big development that we're seeing that you should be mindful of. At this point, not too much information out there, but stay tuned for that over the next kind of days and weeks, as more will be coming out on that. And I should just say from the outset, and I intend to mention again at the end, you can keep an eye on our Williams HR Law blog, where we're frequently posting updates about big developments for employers. We post them weekly there, as well as more regularly on our COVID-19 Resource Center, which you can link to from our website as well. And those are developments specific to COVID-19 on the Resource Center. And so we'll be writing about these developments as more information comes out, and of course, so much more on there for those who want to get more information. There are also a couple of legislative developments for federally regulated employers specifically that I want to briefly mention here before we dive into the rest of our content. We don't have time to get into these in detail, and especially because most employers we expect who are on this webinar this morning will be provincially regulated, and these wouldn't apply to those. But those who may be federally regulated, those tend to be those in interprovincial or international trucking or transportation, telecommunications, and certain other industries. They have some new legislation that they need to contend with this year. That includes a new obligation for federally regulated employers with at least 10 employees to establish a pay equity plan, and those with at least 100 employees or those that are unionized to establish a pay equity committee to help develop that plan. In addition to that, as of January 1st of this year, the Canada Labour Code was amended to require federally regulated employers to really provide really strict harassment and violence requirements for those employers. That's similar to those that have already been in effect for Ontario employers going back to 2016. So federally regulated employers, the time is now to do a lot of those same things that provincially regulated employers have had to do over these past few years. These include things like a requirement for employers to actively develop a prevention policy with respect to workplace harassment, to develop a process for investigating workplace harassment and violence, and a variety of other requirements. And so that's my quick snapshot here that I wanted to touch on some other things. And from there, I'm going to pass it over to Seth to dive into Bill 27.
Thanks very much, Joel. And good morning, everyone. Thanks, Tina, as well, for those introductions. I'll start with Bill 27. Joel touched on a little bit. I'll get in a little more in depth. It was passed in December of last year, received royal assent in December, meaning it came into law. Bill 27 introduces the Working for Workers Act. Interesting name. Introduces sort of a mixed bag of changes that affect employers. Some of the changes are licensing requirements for temp help agencies and for recruiters, and the details on that are TBD, and mandating employers to allow delivery persons to allow access to their own washrooms if performing deliveries. So today I'll touch on two very important developments, though. They've got the most attention, I would say: right to disconnect policy requirements and the ban on non-comp agreements in Ontario. So I'll start with the right to disconnect law. So there's been an amendment through Bill 27 to the Employment Standards Act in Ontario, requiring employers with 25 or more employees to implement a disconnecting from work policy, quote unquote. The requirement comes into effect June 2nd of this year. So if you're an employer with 25 plus employees, you need a disconnecting from work policy as of June 2nd. The new legislation defines disconnecting from work as not engaging in work-related communications, right? So employees not engaging in work-related communications, including email, telephone calls, video calls, and the like. So an employer needs this type of policy in place. The most impact will likely be seen on those employees who have work phones or work remotely or work on workplace computers from their homes. There's some issues, though, and practical challenges to the law at this point. At this point, the legislation provides very little guidance as to what has to be contained in the policy. And also, employers will need to determine how they're going to enforce such a policy in the workplace in light of their own work realities and use of company phones and what have you, working outside of standard working hours. The government has, though, recently this week come out with some guidance as to what this requirement actually means, but has largely affirmed that there's generally no strict requirements as to what has to be contained in one of these disconnecting from work policies. But employers really need to be careful in drafting disconnecting from work policies, because depending on how you draft the policies, you could actually create a greater legal right for your employees than is required under the Employment Standards Act, and sort of hamstring yourself to a higher standard of rights for your employees than is actually required by law, which could result in additional heightened liabilities for you as an employer when employees are leaving, right? So I'll move on to non-competition agreements in Ontario. So the Working for Workers Act also now amended the ESA, Employment Standards Act, to prohibit employers from using non-competition agreements, right, that prevent employees from competing with the employer when they leave. The restriction applies to all employees. So an employer generally cannot use a non-competition agreement in Ontario with certain exceptions, right? So you can still use a non-competition agreement in the context of a sale of business, right, where you're prohibiting a seller from competing with that business they just sold. And also you can have a non-competition agreement still for an executive level employee. This was a splashy change in Ontario in December when it came out, received a lot of media attention, but really the change doesn't do much to change the law. Non-competition agreements were already very difficult at common law to enforce by employers and can only be used in very exceptional circumstances. And note importantly that this new prohibition doesn't prohibit an employer from implementing a non-solicitation restriction, right? Prohibiting an employer from, or an outgoing employee from soliciting clients or soliciting employees on their way out. Those type of contracts are still on side. So I'll move on to the takeaways when it comes to Bill 27. First, identify problem areas, right? So given that affected employers will need to have a right to disconnect policy as of June 2nd of this year, they're going to need to turn their minds to, okay, what employees are going to be affected by this and what measures are we going to implement to permit employees to disconnect from work. And an important thing to note there is you don't need to have a universal policy that applies to all employees the same way, right? Your policy can differentiate on employees based on their position, based on the functions that they perform for the business and their general requirements, right? So it would be prudent for an employer to carefully assess their workplace and carefully draft policies that affect the realities of their own business, right? So this also, keep in mind, may necessitate training for managers and for employees to understand what the new requirements are, right, and how to manage them. Second, employers need to stay on top of developments. This is new legislation, and we could see regulations that come out that provide some context as to what has to be contained in a disconnecting from work policy, or that even may affect the non-competition agreement requirement. And Joel also mentioned the remote work monitoring law that we expect to see as well in the near future. So for that reason, employers need to keep their ear to the ground on any developments that come down, because, in advance of the election here, there's a lot of changes that are coming out very quickly and some requirements, right, that employers are going to need to meet by the end of the year. So very important to stay on top of developments. Third, just specific to non-comp restrictions, I mentioned the executive carve out there. You can still have a non-competition agreement for an executive employee. employers are going to want to be very careful in relying on that exemption, right? Because now it's not just if you can't use the non-competition agreement, it's not only now that it's potentially unenforceable, right, against the employee, it could also be a breach of the Employment Standards Act, which could in many ways result in penalties or additional liabilities in certain contexts. So with Bill 27 wrapped, I'll move on to employment agreements. Employment agreements are always a hot topic. I mean, the past 5+ years, employment agreements, termination clauses in Ontario specifically, but across the country, it's always been a hot topic for employers because these are the documents that really limit employer liability upon termination of employment when they're drafted appropriately, right? And so I'll move on to a big decision, a decision that keeps popping up for employers. That's Waxdale and Swigon North America. That was a 2020 Ontario Court of Appeal decision. And why are we talking about it? Well, the Supreme Court of Canada, Waxdale was appealed to the Supreme Court of Canada in 2021. Many employers had hoped, okay, it's going to go to the Supreme Court of Canada and maybe they'll overturn the Ontario Court of Appeal decision, which was an employee-friendly decision. Unfortunately, that wasn't the case. The Supreme Court of Canada denied leave to appeal, which essentially means that Waxdale is now good law in Ontario, and it's certainly persuasive in other provinces as well. Essentially, just as a reminder, what Waxdale boils down to is all termination provisions within an employment agreement, think with cause provision and without cause provisions, they must be considered together when determining their enforceability. So if there is an issue with the with cause provision, that will technically at law prevent the employer from relying on the without cause provision and could void the entire termination set of termination provisions within your employment agreement. And that's important because when a termination with or without cause provision is void, an employee is entitled to claim their common law reasonable notice, which can be very significant. It can generally go up to as much as 2 years worth of pay or more in certain circumstances, depending on the age, years of service and nature of employment of the particular employee. But the important thing to note is it's certainly much more than the statutory entitlements under the Employment Standards Act. And generally, it's going to be more than what employers are prepared to contract for, right? So Waxdale is good law. So it really tells employers that you need to assess your termination clauses at this point and assess whether there's any gaps, because we've seen an explosion of wrongful dismissal claims since Waxdale came out, because many termination provisions in Ontario, probably in excess of 80% of them, have been rendered void as a result of this decision. So with that, I will turn to the next topic here, which was really an interesting argument that we saw by employers with some success in 2021, but some failure, if you will, unfortunately. So the sophistication of the employee was asserted as an argument in 2021 as sort of a Waxdale killer, right? An attempt to go against Waxdale. Essentially, the employers in this decision, Raman and Cannon Design Architecture, argued that sort of where an employee received legal advice and negotiated parts of an employment agreement, the termination provision, despite technically violating the Employment Standards Act, should be enforced, right? Because the parties in their negotiations, they intended to comply with minimum employment standards. So despite a technical error in the drafting, where the employee was sophisticated and of the same mind as the employer when they came to the agreement, the clause essentially should be enforced, right? So many viewed that decision as a potential defense to Waxdale that could save an otherwise technically invalid termination clause. Unfortunately, two subsequent decisions here, Livshin and Campbell-Givens in Ontario, declined to follow that Raman decision. Both held in the case that the sophistication of the employee receiving legal advice beforehand when signing off on that employment agreement, it doesn't matter. It's irrelevant. What matters is the language in the employment agreement. Does it comply with minimum employment standards? So does it comply with the Employment Standards Act in Ontario? Does it comply with the Employment Standards Code in Alberta? Every province has a piece of legislation that provides minimum standards. The courts in those decisions held there's only one assessment as to whether an agreement is valid. That's, does the agreement comply with what's in that minimum employment standards legislation? So while this Rahman decision, sophistication of the parties, gives employers a potential angle to argue that certain employment termination clauses are valid, employers really need to proceed with caution in doing so. It shouldn't be seen as an alternative to a fully good and valid termination clause. So I'll move on to the takeaways. First, just as a reminder, I won't say hash on this too much. Employment agreements must meet minimum employment standards, right? So if you're Ontario Employment Standards Act, you need to make sure that your termination clause specifically, but everything in the employment agreement meets those minimum standards. And employee sophistication. So as I mentioned, that may be a defense, right, to a technically invalid termination clause. However, it's going to be a long shot argument, right, given the subsequent case law we saw over the last year. And just a reminder, an invalid termination provision with or without cause, that's going to substantially increase an employee's potential termination payments, right? The liability that you have to an employee when they are dismissed. So for that reason, it's very important. Like now is more important of a time than ever, given the trends in the law, for an employer to reassess their employment agreements and assess whether there's any gaps, right, that need to be assessed for legal enforceability, given this really strong trend we've seen in the case law in favor of employees. So I'll move on to workplace investigations. So from one hot topic to the other, workplace investigations that's another area of the law where courts are getting increasingly strict as to how employers, whether they identify situations for of harassment and where a workplace investigation is required, and how they conduct these workplace investigations. So just as a reminder, in Ontario, workplace harassment is covered under health and safety legislation, and where an employer learns of harassment or receives a harassment complaint, there's an obligation, a statutory obligation, to conduct an investigation and meet certain other obligations. So it's more important than ever that an employer knows when to investigate and how to conduct an investigation. And there can be substantial costs and implications of getting an investigation wrong and failing to conduct an investigation where appropriate. Just this past year, we saw a record-breaking near $200,000 in general damages awarded by the BC Human Rights Tribunal. We've seen similar awards in Ontario as well, where an employer has failed to conduct an investigation or inadequately conducted an investigation where they should have done so. So the awards continue to go up in this McGraw and Southgate case. Will show us just that. And I'll take you through the case because the facts are important when we're talking about investigation and harassment scenarios. So McGraw and Southgate was a 2021 decision in Ontario where the court had found that an employer had breached its duty of good faith in the manner of dismissal, in part because it had conducted a flawed investigation into allegations against an employee that preceded her dismissal. And ultimately, this decision resulted in the court awarding that employee a total of nearly $200,000 of general damages in addition to her termination entitlements. So the employee got what they were entitled to in any event because of their dismissal. And then the court said, well, employer, you're going to have to fork up $200,000 on top of that to pay to this woman because of the way that you treated her on her way out. Very avoidable type of damages, but it shows what can happen where an employer goes wrong. It doesn't handle these type of sensitive issues appropriately. So in that case, it involved a female employee of a fire department who was the target of a number of salacious rumors, right, about her sex life and about alleged affairs, actually, with the fire chief working in the department and with other male employees who were working in that department. The employer got the rumors and they decided to conduct an investigation, right, into whether any of these rumors could be substantiated. They did a very bad job of investigating the rumors. A number of things that were pointed out in the decision is the investigator never met with the employee in question or the fire chief about the allegations, when one of the allegations was there was a alleged affair between them, failed to consider a number of pieces of relevant evidence, and the employee in question, who was ultimately dismissed, was never even informed of the findings of the investigation at the end of the day. So a number of key steps were missed in that investigation, and based on that faulty investigation, and against the advice, actually, of the employer's HR advisor, the employer decided to dismiss the employee, right? So the employee, as a result, brought a claim for wrongful dismissal, sued them in court. The court provided that the allegations were, quote, fantastical rumors, many of which could not be substantiated through any evidence, despite the employer's attempt at an investigation. The court also found that the employee had been treated by a sexist double standard, as none of the male staff involved had been subject to discipline at all. So she'd been dismissed. None of the male staff had been disciplined in any way. The court also found that the investigation was inadequate for many of the reasons I went over before, riddled with procedural shortcomings, specifically noting that the failure to meet with the employee in question and key witnesses was a major procedural gap. So the court ultimately awarded the woman, the employee, 6 months pay in lieu of notice. So that's her termination entitlement, regardless of any treatment, in addition to a nearly $200,000 worth of general damages for moral damages, discrimination under the Human Rights Code, defamation, and punitive damages, right? So McGraw and Southgate really shows how seriously courts are taking these types of situations, and how seriously they're looking at investigations, right? And how they're conducted. So I'll move on to some takeaways based on that case. First, McGraw highlights that you really need to be careful as an employer how you deal with allegations of employee misconduct, not only for the complainant's sake, but for the respondent, right? Because McGraw was a respondent case where the alleged sort of shortcomings affected the person who had been accused of the conduct, right? So it needs to be looked at in both ways, because failing to get these investigations right, doing them when you have to do them, could result in substantial liability. And key to investigations is procedural fairness, right? You may have taken that from the McGraw decision I just covered. At minimum, the parties involved, the complainant and the respondent, must be given a chance to respond to the allegations. That's not a requirement you can skirt as an investigator. Investigation should involve discussions with all relevant parties, all relevant witnesses, and assessment of the relevant evidence. But procedural fairness, that's going to depend. What that actually looks like is going to depend on the workplace. It's going to depend on the allegations, how many parties are involved, a number of things. And that's why for very complex investigations, where it's serious, complex allegations, or where the employer doesn't have someone who potentially wouldn't be conflicted by way of relationships or reporting relationships or what have you from either of the people involved, it's really a best practice in some situations to retain an external third party who can come in, be neutral, unbiased to the situation, and to conduct the investigation. So, and as McGraw highlighted, that case I just went over, the more serious the allegations and the outcome of the allegations, the more vigorously a court, right, a lawyer on the other side and the court and tribunal is going to scrutinize that investigation process and whether all the stones were uncovered or whether it was a faulty process, right? So given the importance of investigations, like investigations is becoming a key sort of consideration for employers in the realm of employment law in Canada now. So given that growing importance, employers really should undertake a systems and process review of their own investigation processes, right? What's the complaint procedure? Who conducts the investigations? How do they conduct the investigations? There's a number of considerations to be made there, and review if there's any gaps in areas for improvement. And ideally, it should be an external party who's looking at that and giving you recommendations and assessment as to how you can improve, right? So with that, that covers my my three areas, and I'll kick it back over to Joel to cover COVID vaccination policies.
Thanks, Seth. And so, as Seth said, I'm going to wrap up here with the COVID-19 vaccination policy discussion before we shift into the Q&A portion of the presentation. And just a reminder there for everyone, I see a few of you have put some questions in the Q&A already. Thank you. And anyone else who does have questions, please go ahead and populate that Q&A, and we'll get to as many as we can before 10 o'clock this morning. So, as I said, I have the pleasure of talking about COVID-19 vaccination policies, a topic that COVID-19 generally being a topic we think all wish we could stop talking about at this point. I think we all were hoping this pandemic was going to be over long, long ago. And I don't mean to be the downer here this morning, but it's becoming clearer and clearer that we're in it for the long haul. I can speak from personal experience. If you can hear my voice is a bit off, I'm actually just recovering from COVID-19 myself. I had it last week. And I think this is something that so many of us are dealing with or have been dealing with recently, and just goes to show this issue is continuing. And of course, that means it's continuing for employers as well as us individually as well. Now, the pandemic, of course, is continuing to create risks for employers, create issues for employers and how work is performed and how liability might come to the employer. One of the things that employers need to be mindful of, the rules just keep on changing. Lockdowns are implemented, lockdowns are then lifted. Each time there's a new lockdown, there are changes in the rules for each specific lockdown. Now, I'm hoping that this latest lifting of the restrictions that we're about to see in the coming weeks will stick. I'm sure we all are. But I hope the same in the fall of 2020 and the summer of 2021, and we all know how that turned out. So perhaps I'm being pessimistic here in a cold February day. But we've seen it happen a couple of times, and I think that employers need to be ready for continued lockdowns, continued rules that may come back into effect to ensure that you're taking the right steps as an employer. In addition to the lockdowns, government benefit programs for businesses and for individuals keep on being extended and expanded and changed all the time. This month alone, the Canadian local lockdown program and Canada worker lockdown benefit have been extended. Most recently up to March 12th, after a couple of weeks before that, having the criteria be expanded for those programs. Those are just a couple of examples. So again, the employers need to stay on these things and be mindful, because things keep happening, things keep changing that you need to know about and consider as an employer. So of course, the big issue around the pandemic is vaccination policies. Vaccines obviously became widely available in Ontario and in Canada. Starting earlier in 2021 and certainly throughout 2021. And employers have continued to be impacted by COVID-19 outbreaks, modifications to the way that work needs to be performed because of those changing rules I spoke about, and of course, concern about employee and client health and safety. And because of all that, a lot of employers introduced vaccination policies last year, and some employers are still continuing to implement those policies now if they haven't done so already, especially as the province is trying to get back to normal. Employers are trying to, in many cases, come back to the workplace now after having spent a lot of the last 2 years having employees work from home. And of course, there's risks that come with that. So employers are looking at these policies, rightfully so, to try to protect their people and of course comply with their occupational health and safety obligations, to take every precaution that's reasonable to protect employees. In many cases, implementing these types of vaccination policies may be a way to show that you're complying with those obligations under health and safety legislation. Now, we've assisted countless clients with these policies in these past few months. I'm sure Seth would agree. It felt at times over these last few months that we were drafting or reviewing these things for weeks at a time. Now, these vaccination policies can take many different forms. Employers do them differently depending on their circumstances. So these policies may impose significant restrictions on unvaccinated employees. Sometimes that it requires unvaccinated employees to undergo regular testing. Sometimes it requires unvaccinated employees to work from home for a period of time, to wear enhanced PPE, to perform their work in a different manner to try to reduce the health and safety risks associated with their vaccination status. In other types of these policies, these vaccination policies are mandatory for all employees, subject to human rights considerations that I'll talk about in a second, or they're mandatory for certain employees. So employees in certain types of employees, certain departments, those who deal with certain clients or go to certain client sites where vaccination is particularly important. It's mandatory for them, but not necessarily all. So these, again, can take all sorts of different forms. And every employer just really needs to assess its own level of COVID-19 related risk. That should consider, the employer's industry, the specific employer's workplace realities, and the manner that work is performed at that specific employer's workplaces to determine what type of policy is appropriate, is best for that workplace. Now, although there are so many different types of these policies that can come into effect, employers have generally implemented, those employers, I should say, that have implemented mandatory policies have generally had one of three consequences for their unvaccinated employees. One is an unpaid leave of absence. Another is a termination without cause. So employees who are not vaccinated are let go without cause and paid whatever their termination entitlements are, either under their contract, if there's an enforceable termination clause, which Seth was talking about, or at common law, that's the up to 2 years of compensation that Seth was talking about if there isn't an enforceable termination clause. And then in other cases, employers are actually letting employees go for just cause, so without compensation, for failing to be vaccinated against COVID-19. And so I'm going to be discussing the legal implications here for employers that have implemented or are considering implementing these different types of policies. But the first key consideration that I want to get into here is accommodation of employees who are unable to be vaccinated for human rights related reasons. And so, unfortunately, at this stage, there's really limited case law about when employees are entitled to exemptions from vaccination requirements as a form of human rights accommodation. So just to really, really quickly set the stage for everyone who may not know, under the Human Rights Code in Ontario and under the Canadian Human Rights Act for federally regulated employers, employers have an obligation to accommodate employees who are unable to meet the normal duties of the job because of protected grounds of discrimination. And so if a new requirement of the job is created that people must be vaccinated, certain employees who are unable to be vaccinated for protected reasons, or for reasons related to those protected grounds of discrimination under human rights legislation, they are entitled to accommodation if they are legitimately unable to be vaccinated for those protected reasons. Now, although there's not case law out there, we can draw from more general human rights principles and case law in other circumstances, other contexts outside of COVID-19 vaccination specifically, which really tells us that there are two protected human rights grounds that might really be relevant to vaccination requirements. The first one is medical exemptions, so disability-related accommodation, and the other is creed-related accommodation. So creed is, in large measure, it means religion. There are certain distinctions where creed can be a bit broader than religion, but in most cases, the vast majority of cases, when we talk about creed accommodation, we're talking about religious accommodation. So when it comes to the medical or the disability accommodations, there are certain forms of disability that will restrict employees' abilities to be safely vaccinated against COVID-19. But keep in mind, these are very rare. The most common one that we see where there are legitimate exemptions are allergies to COVID-19 vaccines. But even though these are so rare, it doesn't stop employees from seeking disability-based exemptions for other reasons as well, outside of those that are more generally accepted to be legitimate bases for a disability accommodation. And we've been advising clients on so many of these requests over these past few months. Some that I've seen personally, requests for accommodation on the basis that the employees are terrified of needles, so they have a severe needle phobia, and the suggestion that that amounts to a disability under the Human Rights Code. Some on the basis that employees are pregnant or are trying to become pregnant or are breastfeeding, and there are concerns about what vaccination would do for them. Despite that there's significant health information out there from health authorities and health professionals to suggest that it is in fact safe to be vaccinated for most people in those circumstances, and in fact better to protect the pregnant or potentially pregnant mother and child. And then even more frustrating for employers is that some doctors who are personally or politically or philosophically opposed to vaccination mandates have just been openly giving medical notes to anyone who asks for one, to say that the employees are medically exempt from vaccination without there being a legitimate basis for that. So those are some of the medical issues. In addition to that, creed or religious-based beliefs may legitimately entitle employees to not be vaccinated as a form of accommodation in certain circumstances as well. There are certain very niche religions that do maintain a broad belief against any form of vaccination, but again, these are niche. Very few Canadians do adhere to those religions, and so those are pretty rare situations. What's trickier for employers to deal with when it comes to accommodation is that human rights adjudicators in Canada have generally accepted that an employee may be entitled to a religious-based accommodation of a religious belief that they hold personally, even if that belief that they have is not fundamental to the core beliefs of the religion more broadly. So essentially what I'm saying there is, there are potential circumstances where an adjudicator may say, even though your major religion, let's say it's Christianity does not oppose fundamentally and broadly vaccination. If you personally believe, and it's a deeply held core belief of yours related to your Christianity, that you shouldn't be vaccinated for reasons related to that religion, that may entitle the employee to accommodation as well. Now, that needs to be distinguished from personal beliefs that are not deeply core held beliefs related to religion or creed do not entitle employees to accommodation. The Human Rights Commission of Ontario has come up with a policy to specifically confirm that, which is based on the law as it exists anyway. But it can be really hard to distinguish between personal beliefs and religious beliefs. And so for employers who are facing these types of requests, it can be really difficult to determine whether an employee is legitimately entitled to an accommodation or whether they are not entitled to an accommodation and they should be required to be vaccinated like other employees to help protect all employees and potentially clients' health and safety. Now, unfortunately, anti-vaccine groups and advocates are well aware of the kind of difficulties and challenges in the law around creed versus personal beliefs. And so that's led a lot of employers to receive requests for accommodation on the basis of alleged religious beliefs, even when those may not really be legitimate. We've helped clients who have received requests requesting accommodation on the basis of Christian beliefs, Hindu beliefs, many other major religious beliefs, despite that these major religions generally do not oppose vaccination as more broadly. And so employers do have an obligation to consider these requests in good faith to ensure that they comply with their human rights obligations. And if they deny one of these requests when the employee is legitimately entitled to accommodation, if an adjudicator would later determine that they are entitled, there can be really significant liability for employers. And so, we're starting to see more and more of these claims where employees have had their accommodation requests rejected on the basis that they're not legitimate. And they're starting to bring claims more and more against employers to say they've been discriminated against and they should be entitled to significant damages. Now, these human rights claims are just one of the type of claims that is really leading to this flood of litigation that we're starting to see related to vaccination policies. So I mentioned before, employers with mandatory vaccination policies have typically imposed one of three consequences against employees who refuse to be vaccinated: an unpaid leave for some period of time, whether it's definite or indefinite, a termination without cause, or a termination for just cause. And these different types of consequences for employees who don't comply with mandatory vaccination policies are leading to and have been leading to different types of civil actions by non-unionized employees against their employers. So one that we see commonly is constructive dismissal claims. And so these claims are most likely where an employee is placed on an unpaid leave as a consequence of failing to comply with the policy, but it can happen in other circumstances as well. Wrongful dismissal claims, on the other hand, are more commonly where employers actually let employees go, so they intentionally let the employee go rather than the employee having to assert constructive dismissal. And those wrongful dismissal claims are certainly more common where employees are let go for just cause, where the employer asserts that they don't have to pay out the employee's termination entitlements. But even if the employer dismisses the employees without cause, unless there's a very solid termination clause or the employer is generous in paying out notice or pay in lieu of notice at the higher end of the potential range of the likely notice period for that employee, these wrongful dismissal claims are still likely. And then, of course, I mentioned the human rights claims. These can be standalone claims where employees bring human rights claims before the Human Rights Tribunal, asserting discrimination or failure to accommodate. But they're more commonly being seen where employees are put on leave or let go after having their accommodation request rejected, where the employees are asserting that they were discriminated against and wrongfully dismissed or constructively dismissed because of the consequence that was imposed on them for not complying with the policy. Now, to this point, we still haven't seen any case law in Ontario that demonstrates how the courts will respond to these claims. As the old adage goes, the wheels of justice move very slowly. But we are seeing these claims going through the courts, and we expect to see this year some of these decisions start coming out to give more guidance to employers. But right now, employers are somewhat blind in how they deal with these things. But with that said, when considering general legal principles, we as employment lawyers can assess whether and when these claims are likely to succeed. And generally, whether a leave will amount to a constructive dismissal or whether there will be just cause for dismissing an employee who refuses to be vaccinated are going to depend on those same circumstances that I mentioned employers should be considering when developing policies. Those include the nature of the workplace, the way that work is performed, and other factors as well. Now, even though some of these considerations are different, non-unionized employers can look to arbitration decisions for guidance, because we have started to see a number of decisions where arbitrators in unionized workplaces have assessed these COVID-19 vaccination policies and whether they are legitimate or reasonable. I know we're running out of time here, so I'm going to be quick through this union litigation section. But just very generally, in unionized workplaces, a lot of those same factors that I mentioned are relevant to courts assessing the legitimacy of these policies are going to be relevant to unionized workplaces as well. The big difference is that in unionized workplaces, arbitrators also need to consider whether the policy violates the collective agreement between the union and the employer, which governs it essentially forms the employment relationship, effectively the employment contract between the employer and all of those unionized employees. So there are a couple of cases that we've already started to see, as I mentioned. The first, the United Food and Commercial Workers Union, that involved a security company where security guards were assigned to work at different client sites. And many of those clients had requirements that implemented requirements that security guards at their sites had to be vaccinated against COVID-19. In that case, the collective agreement actually had an article that said that employees would need to be vaccinated if the client required them to be vaccinated against different types of things. In this case, of course, COVID-19 is what's relevant. And that's a pretty uncommon article, but that did exist in the collective agreement. And it said that if employees refused to be vaccinated, they could be required to get vaccinated or be reassigned or put on leave. And so in that case, the employer implemented a mandatory vaccination policy, and the arbitrator upheld that as reasonable, in large measure because of that fairly rare article that they had about vaccination. The next case here, Electrical Safety Authority. In that case, the employer had a pretty similar vaccination policy, which required everyone to be vaccinated unless they were unable to be vaccinated for human rights reasons. But in that case, the workplace and the work context was very different. Most of the employees in that bargaining unit performed their work from home. And so since they were working from home, the arbitrator said that the policy was not reasonable. It wasn't reasonable to mandate vaccination because the employer wasn't able to show evidence that that policy was required to address the health and safety concerns that the employer was trying to address by implementing the policy. The arbitrator accepted an argument from the union that a policy requiring COVID testing in certain circumstances would have been sufficient to address those health and safety concerns. Now, I'll just really briefly talk about one more case here involving the Ontario Power Generation. And this one did not involve a mandatory vaccination policy. It involved a policy that said if employees refused to be vaccinated, then they would have to undergo regular COVID-19 testing, and they would have to pay for those tests themselves. And if they refused to be tested, they'd be put on leave for 6 weeks, and then they'd be let go if they continued to refuse to test or be vaccinated. The union challenged a bunch of elements of that policy, and largely the policy was upheld by the arbitrator as reasonable. But the arbitrator in that case did say it was unreasonable to require the employees to pay for their own COVID-19 tests. So while it was reasonable to require the unvaccinated employees to get tested regularly, the arbitrator suggested that the employer would have to pay for that to be a reasonable policy. And so now I'll quickly hit on some takeaways for this. And again, I know we're coming up on 10 o'clock here. What we can do is stick around for an extra 10 minutes or so until about 10 after 10 to make sure we can get to some of your questions. But we understand that some of you may not be able to stick around with us past 10 o'clock. So for those who can't, I thank you for attending here this morning and joining us. But for those who can stick around, I look forward to addressing a number of your questions here over the next few minutes past 10 o'clock. So like I said, some of the takeaways here around vaccination policies. The key thing, I mentioned it already, accommodate creed and disability exemptions where there's a legitimate accommodation need, and assess those carefully to determine whether there is a legitimate accommodation need. If you're not sure, get legal advice, because this is a really tricky thing to consider. Also account for your workplace realities. Like I said, the reasonableness of a vaccination policy in either the unionized sectors or non-unionized workplaces, and including whether unpaid leaves will be considered reasonable or would be a constructive dismissal, or whether terminations for cause might be upheld, are always going to depend on the workplace. And the level of risk in the workplace is key. For example, a just cause termination for violating a mandatory vaccination policy is a lot more likely to be upheld against an employee who works at a hospital with sick and elderly patients compared to against an employee who always works remotely from their own home. You also want to consider the constantly changing pandemic environment. It's dynamic. The circumstances are shifting. You need to consider those circumstances as you implement and continue to amend your vaccination policies. We keep seeing different dominant strains of COVID-19 with different variants that have different levels of transmissibility, different levels of severity, different levels of effectiveness in response to testing or vaccination, and all these different factors need to be considered because they're going to impact whether these policies are reasonable. As I said, obtain legal advice. This stuff is tricky. There's just no way around it. It's complicated, and if you are looking at these policies, especially the more severe mandatory policies, I would encourage you to get legal advice from your employment lawyers who really understand these concepts well to make sure that you're not stepping offside and you're not going to be on the hook for massive amounts of termination entitlements, especially, as Seth was saying, if you don't have those enforceable termination clauses in your contracts. And ultimately, assess your own risk tolerance as an employer. Ultimately, what your decision is going to be in implementing and creating and amending these policies is going to depend on your own risk tolerance. A lot of employers are taking risks in implementing mandatory policies or more stringent policies, even when they understand that this may result in wrongful dismissal claims and constructive dismissal claims, because they feel it's just so important from a health and safety standpoint to implement those things. So, as an employer, as a company, ensure that at the management level, you are really assessing both the legal but also the business implications of these decisions to make sure you determine what's the best approach for your workplace specifically. Okay, so that brings us to the end of that section of the content. I'd just like to let you know we do have a newsletter that covers the topics we've discussed here, as well as many more and in much more detail that you can download from our website. This is a newsletter we put out every year, our year in review newsletter, and we also put out a number of other newsletters year after year as well. So I encourage you to go and read that newsletter and any others that may interest you, along with our blog and resource center that I spoke about before. Okay, so with that, I'd like to shift us into the questions here before we wrap up. And so I see we have quite a few questions here. So we'll try to get through as many as we can before we wrap up in time. So the first question that I see here, and I remember kind of seeing it when it popped up, it asks about implementing a right to disconnect policy for an IT company where employees are required to be available 24/7. And the question is, how to develop a policy in that case. I know that policy or that question was asked before Seth talked about, some of the really key considerations to assess the specific realities of every employee and every group of employees and determining, what's reasonable for your workplace. And so I won't get into that in further detail. I think that answers that question. Again, spend the time that Seth was suggesting that you do to really consider what makes sense for your workplace. And, considering the type of work and whether employees need to be on call is a crucial element to consider when you're putting these policies together, along with, of course, understanding the limits to the requirements under that policy that Seth spoke about. So another question that we had here, and I'll put Seth on the hot seat. This covered one of your topics. And the question here is, if an employer has past employment agreements which had a non-competition clause, does the employer need to create and give their current employees a new contract with that non-compete clause eliminated from it?
Well, from a practical perspective, it may be a good idea to do that. There's some technical requirements. For example, you need to give consideration to an employee for a new employment agreement. There's been a case and the Ministry of Labor has actually come out and said that this ban on non-competition agreements and the particularities of the rule now don't apply to existing non-competition agreements that were implemented before October 25th of 2021. So if you have an agreement that was entered into prior to that date, the common law rules apply, right, to that non-competition agreement. Now, the non-competition agreement as drafted may be unenforceable because it is very difficult to enforce those types of restrictions. So if you want to rely on any type of restriction, right, from after an employee leaves your employment, it may be a good idea to implement a new type of agreement that is more narrowly tailored and meets the specific legal requirements. And if you're not dealing with an executive level employee, it's going to have to be a non-solicitation agreement, right? You won't be entering into a non-competition agreement going forward. But to answer the question plainly, if you had a previous non-competition restriction, this ESA amendment ban on non-competition agreements does not apply, right? So you're still permitted to have that. You can still rely on it if it meets those existing common law standards pertaining to non-competition agreements.
All right. Thanks, Seth. I'll keep you on the hot seat here with some more questions about Bill 27, knowing that that's a very hot topic here. So we have another question. Is one option to use a non-solicitation clause in the employment contract instead of a non-compete clause?
Yeah, absolutely. So that's non-solicitation is going to be your sort of best way to respond to this non-competition agreement, right? If you were if you were an employer who was using non-competition clauses as a standard part of your employment contracts, you're going to have to move away from that now, right? And non-solicitation provides you with the best sort of next step to protect your interests as an employer, right? Because what a non-solicit can do is it can prohibit an employee, from soliciting clients, soliciting prospective clients, soliciting employees, right, to leave the company or organization after they leave, right? Now, and Joel and I look at these types of clauses on a standard basis. We look at these things all the time. We assess them. There's very strict legal requirements, though, around what a non-solicitation clause needs to sort of have in there. It needs to be narrowly tailored. It needs to be sort of the least imposing on the employer that it possibly can be, employee that it possibly can be, while meeting the employer's interests, right? There needs to be a legitimate interest in prohibiting this person from soliciting clients and employees on their way out. But to answer simply, yes, you can have a non-solicitation clause provided it meets those existing legal requirements for such a clause.
All right, thank you, Seth. And I'll just really quickly answer another non-compete Bill 27 question before I deal with a couple of the vaccination policy questions that we have here. And so we have a question, is whether the non-competition clause restriction is only for companies with 25 or more employees, or is it for employers of all sizes? And I can just confirm that the non-competition restriction is for employers of all sizes. It's the right to disconnect policy requirement that applies only to employers with at least 25 employees. So a couple of questions that I want to touch on here around the mandatory vaccination policy issue. One question we have asks, isn't it fair to say that mandatory vaccines directly conflicts with the non-discrimination policies in force with companies? And I would say no, it definitely does not. Anti-discrimination, non-discrimination policies are generally related to discrimination on the basis of protected grounds under the Human Rights Code. And so if somebody can't be vaccinated, again, for medical or religious reasons, yes, they need to be accommodated. But generally, having a mandatory vaccination policy does not violate an anti-discrimination policy, because the personal decision to not be vaccinated, or even the political decision to not be vaccinated, are not protected grounds under the Human Rights Code in Ontario. And so employers, essentially, it's legal to, quote unquote, discriminate against, treat differently those employees who are not vaccinated, as long as it's not because of medical or religious reasons. We have another question about these vaccination policies. I think is an interesting one. And the question is, you can still get COVID-19 even if you're vaccinated. And as I said, I'm an example of that myself. I'm triple vaccinated and got COVID-19 last week. How do we require this when it doesn't seem to matter if you're vaccinated or not? And that's a valid point. These vaccination policies, the reasonableness of them do need to look at different things. And certainly with the Omicron variant, it seems that kind of double vaccination does provide less protection than it did against other variants. And there's a suggestion that being boosted might be really important to help protect against these current variants that are dominating right now. These are some of the things that need to be considered. How much protection do these mandatory vaccination policies provide? I mean, the science is very clear to say that being vaccinated, even if you can still get COVID-19, helps make it less severe. And so there's certainly an interest for employers to help limit the severity of illness that their employees may get. But again, all these different factors need to be considered, and the effectiveness of vaccines is going to impact the reasonableness of these policies as well. So I know we're just at the end of time here. I think we'll wrap here, not to keep everyone any longer. I know we've already kept you kind of longer than we intended to this morning. I know there's a question about whether the recording and presentation deck will be sent to attendees. So why don't I pass it over to Tina if you want to capture that one. I know that there's a plan for the deck here.
Thanks, Joel, and thank you, Seth. So the recording of this event will be put on our website, and we can certainly send an email to everyone who attended with the link to where it be located on the website.
Thank you, Tina. And thank you, everyone, for attending here this morning. I'm hopeful that everyone was able to take some really helpful pieces of information back to your companies.
Have a great day.